what do we see in that picture? We see a San Bernardino County Sheriff emblem up in the corner of where he said he found the cell phone. Okay, here I'm starting at page 8. Okay, Mr. Fall Harbor. Daniel Fall Harbor for Mr. Owen. He is present in custody. Mr. Gass. James Gass for Mr. Waterman. He is present in custody. Mr. Myers. Doug Myers on behalf of Mr. Carver. He is present in custody. The court. All right. And we are here for trial. Everybody still ready? Mr. Token. Yes, Your Honor. Mr. Fall Harbor. All ready. The court. We've had some discussions off the record conducting our pre-voir dire conference in accordance with the court rules. Any potential witnesses not to enter the courtroom and not to discuss their testimony with any other witnesses during the pendency of the trial. Originally, before counsel started conflicting off of the trial, counsel for Mr. Waterman had filed a 995 motion regarding count 4, which was the 209.5 kidnapping for another purpose, and I believe it's kidnapping for robbery or carjacking in this case. The kidnapping counts. And I think that was joined in by everybody. Everybody still want to join in on that, Mr. Myers. I do. Just to be clear, I think it attacks both of the aggravated kidnapping counts. Mr. Token, count 1, and the court. And Judge Smith basically did not hold the defendants to answer for the kidnapping count because he thought it essentially was for the purpose of not effectuating the robbery, but for helping defendants conceal their crime and was subsequent to the actual robbery. The court did review some cases. People v. Larson, specifically Laursen, is found at 8 Cal 3rd 192. It's a 1972 case that the court thinks is dispositive on the issues. But anybody want to be heard with respect to this issue? Mr. Token. Your Honor, I think simply because there is a permissible inference that perhaps the defendants did in fact engage in a kidnapping in order to conceal the commission of their crime, it doesn't necessarily mean that no other inference can be drawn, including that perhaps they were in fact kidnapping a defendant in order to again continue the robbery or engage in additional robbery. So I don't see how it precludes the people's argument that in fact they did kidnap the victim in order to either rob him and or commit the carjacking. I think the case that the court mentions, which we discussed informally, is on point as to that issue. Legally, rather, that's possible, and I think inference at preliminary hearing kept in favor of the people. So with that, I'll submit. Mr. Myers, submit. Mr. Fall Harbor. Your Honor, the inference were discussed at preliminary hearing, and the magistrate found that the most reasonable permissible inference was that this activity was a straight kidnapping, violation of Penal Code Section 209, and not for one of the specific purposes enumerated either in Count 1 or Count 4 of the information. In the evidentiary form, the evidence, it appears that if there was any sort of a robbery, an actual robbery, that robbery occurred prior to any observation and transportation of the victim in his vehicle, thus the robbery had been committed. The robbery had been completed prior to any transportation. In terms of a carjacking, there is some question as to, well, whether or not this was any sort of frame involuntary in the sense of the victim in this case, if his version of the events can be believed, version 2, essentially, that part and parcel of what was taken from him apparently was car keys. He was unconscious at the time, and obviously a carjacking requires the use of force and or fear. Since he's unconscious, we can't have that fear element. The force element is somewhat questionable in the sense that we don't know whether or not his car keys were taken from him or whether or not they were still in the possession of one of the defendants from earlier transportation that was apparently with the consent of the victim. That being the situation, I think that the magistrate's finding at preliminary hearing was correct. Submit. The court. Mr. Gass, Mr. Gass, submit it. All right, the court's going to deny the 995 with respect to the kidnapping. The court does think that the Larson case is dispositive. The defendants in that case made the same argument that the usurpation of the victim was unrelated to the robbery since it occurred after the crime had been committed. The court in that case held that if you kidnap someone for the purpose of effecting an escape or perfecting the completion of the robbery by eliminating a witness to that robbery, then it's related. The robbery and the kidnapping in this case were close in time, place, and purpose. It subjected the victim to further risk of harm, and even the court found that the purpose was to essentially get rid of the victim and to help perfect the robbery by perfecting escape and removing the person that could report the crime, and that was the holding of Larson. So I think the court is bound by that holding and will deny the 995 on those grounds. There was one by Mr. Myers as to the whole. Mr. Myers, no. That actually was the prior attorney for Mr. Owen. The court, okay, Mr. Fallharber, because factually he is in a little different position after the preliminary hearing. So I think that the 995 was going to all elements more on a sufficiency of the evidence. The court, all right, so the 995 is denied. Anything else that we can take up this morning? Whereupon there was an interruption in the procedures in order to handle other matters unrelated. The court, back on the record in Owen, Carver, and Waterman. Trying to figure out what further motion in we can address this morning. Mr. Gass, I think we can talk about Ricky Johnson's statement, and there's some things we'd agree to. The court, I suppose that's going to depend on whether Ms. Johnson is going to testify or not, right? Or is there something that we can do? Do we have to have her here to testify? Mr. Token. Right, Your Honor. The court. And my understanding is, based upon discussions we've had off the record, is that Ms. Johnson is likely going to be charged with the events in this case. Mr. Token. Yes, Your Honor. The court. Before we have her testify, I'm going to have to appoint her an attorney before we can address those statements. I have to find out if she's going to testify or assert her privilege or not. She's not here today. Mr. Token, with regard to scheduling, Your Honor, when would the court like me to have her here? I don't know if I can get her here tomorrow, but I think Wednesday would be a better bet than tomorrow. The court, if you do have her, how long is this hearing likely to take? Mr. Gass, I think we can discuss what's in the transcripts, whether she's here or not, or whether she actually testifies the day we discuss it. For instance, I know that I'm going to be objecting to any reference to anyone being on parole or any reference to skinhead gangs. Okay, Mr. Gass, and so we could have rulings on some of those types of issues. Mr. Token, I'm sorry, Your Honor, I don't think we can have a ruling with regard to the skinhead issue. The parole issue I don't have a problem with, but the skinhead issue is not just Ricky Johnson that would be testifying to that, or at least gang affiliation generally. It would be the victim, Ronald Schultz, because it goes to show his fear with regard to these individuals, and I believe it's within the first 20 minutes of his interview that he talks about generally their gang involvement and his fear because of that. So that's a bit more of a longer issue, and it does not involve Ricky. It does not just involve Ricky Johnson. The court, let's see if we can clear the parole issue. Are you going to offer any evidence that anyone was on parole? Mr. Token, no. The court, any motion to exclude any reference to any of the defendants being on parole is granted. The DA doesn't intend to offer it anyway. Mr. Guest, well then we can talk about reference to skinheads. I'd make a 352 objection to any reference to skinheads. The victim I believe, is going to testify that he's walking along and conked on the head from behind and he's stabbed and various things done to him. This is not a case where he's verbally told to do something and out of fear cooperates. There's no indication that he cooperated at all, or that his fear of being hit on the head or stabbed or anything forced him to do anything. I don't see how it's probative or any issue that Mr. Token is going to be arguing about. The court, all right, Mr. Token, do you intend to offer evidence that any defendants is a so-called skinhead? Mr. Token, I do. They were involved in a gang, and the reason is it is relevant. The court, hold on, Mr. Token, yes, sir. The court, first of all, let me find out which of the defendants or all of them do you intend to offer evidence about? Mr. Token, the gang member would be as to all of the defendants. Court, all right, what gang are we talking about? Mr. Token, Cross Family Skins. The court, what would the nature of that evidence consist of? Mr. Token, just that they are a member of that organization, and the reason for that, Your Honor, is because in this case, Mr. Schultz gave different versions of events as to what happened to him. The people have to explain because his credibility is an issue. Why he gave inconsistent statements, why he first told the officers that he was just walking to get something to eat and then got hit in the back of the head, and they came later on and gave those same officers a much more detailed version of events, which included his going to the house to buy drugs, being lured there, and then being stabbed there. So it goes to explain why he gave inconsistent statements, because he was afraid of their gang. Although he did not know specifically, I don't believe he knew specifically the name of the gang. The court, well, what would the proposed evidence be relative to these individuals be involved in Cross Family Skins? What type of evidence do you want to introduce? Do you want to introduce just the victim saying, I thought they were skinheads, which is why I didn't cooperate with the police, or do you intend to do something more than that? Mr. Token. Well, Your Honor, in terms of, well, at the very minimum, I do want to offer his statement as to why. As to he believed that they were in a gang, and that's why he gave inconsistent statements. So, at a bare minimum, in terms of the gang affiliation, I would like to offer tattoos as evidence, for example. The court, do you have a gang expert? Mr. Token, I don't have a gang expert. My investigating officer, however, Detective Whitten, is familiar with the gangs out of Yucaipa. The court, I guess as far as the victim's statement that he was what? Did he fear some sort of retaliation? Mr. Token, he did. Initially, he thought this would all go away if he was kept quiet. Later on, because of their involvement in the gang, thought they were going to reach certain aspects of his life and family, and that's when he came forward and spoke to the police. The court, what aspects of his personal life and family? Mr. Token, that they knew where members of his family worked. That basically they were going to go after his family if he testified. Mr. Fall Harbor, we got these defendants, and to ascribe a statement purportedly maybe or an allusion purportedly made by one defendant to all defendants is going to be a little bit of a stretch. Secondly, I'm unaware of any sort of any ascribing Mr. Owen's membership or anything of that to the Skinhead organization. Third, I don't think we're seeing anything from anyone indicating the law enforcement in some fashion or another, and the reason therefore the law enforcement considers this particular Skinhead organization a criminal street gang under the statute. Mr. Token, well, we didn't charge it, Your Honor, so that's the discovery that we provided wasn't with regard to either 186.22A or B count. We're offering it now to just explain the subsequent conduct of about a witness. Mr. Fallharber, the fact that a vital witness is threatened by anyone, whether they be gang member, non-gang member, person off the street, the threat in and of itself is the important thing, or the alleged threat is the important thing, not the affiliation with the gang. The court, why does he believe these folks are, why does the victim believe these folks are gang members? Mr. Token, because he is. Well, I can't speculate as to why he believes. I don't have the exact quote from the interview. I can get the quote and then we can submit that to the court. But I imagine his explanation of it on the stand is going to be much more in-depth than to quote that I'm pulling out of this interview. Mr. Gass, in-depth. That's even more 352. It's a waste of time, and anyone who has been stabbed and beaten and kidnapping is going to be afraid of retaliation. Nobody was in custody at the time. He was initially interviewed. All he has to say is, I was afraid of retaliation, not afraid of retaliation because they were gang members. They don't have to be gang members to possibly retaliate if someone were to implicate them in a crime. Mr. Myers, I think we need to get down to the details of what he actually told law enforcement about his fear. The police report says he had been withholding information because he was scared of reprisals against himself and his family. If that's fleshed out in the recorded interview and there's something more, we can address that. But that might be relevant. That does not mean you get to prove that they're gang members, in my opinion, Mr. Gass, or even alleged. Mr. Myers, right. It would be natural to be afraid just because of what he alleges that what occurred. The court, I think people are more afraid when there's gang affiliation and groups backing individuals, but I don't know. Maybe I need a little more information before I can make a ruling on it. I think tentatively the victim says, hey, I'm afraid because I thought these folks were gang members. I'm afraid of reprisal from them or either fellow members. It goes to his state of mind and reason why he would or would not be truthful, the officers, and whether or not he's afraid of testifying here and afraid of reprisals or not. I think that's more probative than prejudicial, especially since he's the victim. He's your essentially eyewitness that's going to testify, right, Mr. Token? That and Ricky Johnson has some, but yes. The court, as to whether or not they're actually gang members or not, I think that will require a 402 hearing with the officer, and depending on what is offered for and whether that detective can establish in some way that a gang actually exists and these folks are members, that's going to require a 402 hearing, because I'm certainly not going to say, go ahead and put the detective up and then the jury hears something about, well, I think they're gang members, but there's no foundational requirements. I think I need to, first of all, see if he can establish that before I put it in front of the jury, and then I need to know, is that a motive that these folks are acting together? Does that tie them together in a commission of this offense? Does it? I just need to know. There's no gang allegations alleged. But as I understand the law, you don't have to have the gang allegation alleged to introduce evidence of gang membership when it comes to motive. people acting together, victims' fear of testifying, or fear of talking to the officers. So before we do any of that, I think we have to have a hearing on those things. As far as what the victim is saying, I'm afraid because I thought they were gang members, that's one thing, and I think that's certainly probative, Mr. Token. And it also comes up, Your Honor, with regard to Ricky Johnson, too, because she's aware of their gang affiliations, and if the court remembers, she came forward after she was allegedly told to get into a vehicle and then kidnapped and had a gun pointed at her and threatened and not to testify in this case. So it's going to affect her as well. So I guess the 402 hearings, the court will have to have a hearing with her to see if she testifies or not. Mr. Gass, we've only heard that testimony from Mr. Token himself. Mr. Myers, we don't have anything on this kidnap threat scenario at all. The court, was she interviewed? Mr. Token, she was not, Your Honor, and I'll explain. She was interviewed with regard to the statement that I did provide to defense counsel, the 5-hour interview with the polygraph. There was some confusion between Yucaipa and Banning as to who was going to interview her, because although the crime began in Banning, it ended up in our county. Because it affects our case, Yucaipa wanted to take a hold of it. She was scheduled to go get an interview at Banning, which without my knowledge, she was told allegedly by one of the detectives not to do it, that Yucaipa would be talking to her. I have Detective Witten working on that right now regarding the portion. The court, that she was kidnapped, where does that information come from? Mr. Token, from her, the court. But there's no recorded statements or report from her, Ms. Token. There's no written report. She made the statement to an investigator at my office, but a report has not been generated. As to that, and no investigation has been carried out with regard to that at this point. The court, is there going to be a written report by the investigator? Mr. Token, I'm asking for Yucaipa to write a report and investigate this crime separately. The court, okay. But if you want to offer evidence of that, don't you think the defendants, Mr. Token, absolutely, the court, ought to have that information? Mr. Token, absolutely, I agree. This is kind of a frustration that I'm having with Yucaipa because they're so short-staffed. The detectives have been scattered. The court, did your investigator record their statement from Ms. Johnson? I don't know, but I can ask if Mr. Perry recorded it. Sounds like we have a lot of 402 hearings to do. Is there going to be a motion to bifurcate the priors with respect to all right. Looks like it's alleged Mr. Owen has a prior strike for a 422. Is there going to be a motion to bifurcate the prior? Mr. Paul Harvey, yes. Okay, that will be granted. And it looks like Mr. Waterman has prior conviction for a 211. A motion to bifurcate that. Mr. Guest, yes. All right, that will be granted. I'm trying to find some easy ones. What are the other issues people see us needing to handle before we start the trial? Mr. Token, I have a motion, Your Honor, to exclude any mention to Mr. Ronald Schultz or any discussion at all, him being a child molester, predator, or a pedophile. I think in there was a statement that was thrown out there, and I can't remember which defendant at this point had made that statement, but that explained the reason they stabbed him was because he was one of those, either a pedophile or a child molester or something. And there's no evidence of that. I pulled up his rap sheet. I don't see a conviction for that. I think it's a 352 issue. I think it's hearsay. There's no foundation. I'd like to have, if it's going to be admitted, I'd like to have a 402 hearing before it's blurted out in front of the jury. The court, well, it's one of the defendants that makes that statement, Mr. Token. Yes, Your Honor. The court, is that a statement? Are you intending to introduce the defendant's statement as evidence, Mr. Token? No, I'm not. The court, so which defendant makes that statement? Mr. Token, I think it was Mr. Waterman. Mr. Myers, I actually think this is back to Ricky Johnson because I think it's Johnson saying Waterman told her that's why the attack occurred. The court, okay, again, we have to decide whether Ms. Johnson is going to testify and whatnot. And all right, I don't see how it gets in otherwise. I guess I have to defer on that one. Doesn't sound like something that would be admissible unless you were going to offer it. It sounds like hearsay if the defense was going to offer it. Mr. Token, right. I'm not going to offer it. That's why we already discussed I wasn't going to offer the statements of the defendants. The court, anything else we can deal with? Mr. Guest, there's a large segment of testimony or statements from Ricky Johnson that involved her listening to a conversation speculating about who this guy Joe is talking to and what they were talking about. And I think she needs some coaching from the prosecution to avoid those areas. The court, and again, if she testifies at all, isn't it her speculating based upon one end of the conversation what the person on the other end of the conversation is saying? Mr. Gash, yes. The court, without actually hearing. Mr. Myers, yeah, who it is and what. The court, who it is and what they're saying. Mr. Gash, correct. The court. It poses kind of a problem. Mr. Token. I have no objection to not operating that, Your Honor, unless it can be shown that she can recognize the voice and knows what was said on the other side. Mr. Myers. There's a secondary issue about that. If it's established through foundation who it is and what they're saying because she knows the voice and knows who it is, it's not my client talking and it's not Mr. Owen talking, allegedly. So now we have hearsay Aranda kind of problem. The court. It is. Assuming, does she assume, make statements about any of the other defendants involved? Mr. Myers. It's hard to tell with her because some of what she says is what she thinks is going on, but she does make statements to law enforcement that would lead on to other defendants. She's drawing conclusions. The court. I guess we need to find that out. I can make that part of the 402 hearing that we do with her. She may not even be available as a witness. That would solve the problem. Mr. Myers. Yes, it would. The court. Sounds like Miss Johnson. Well, it's either really short or really long, depending. And her attorney, can you get her here tomorrow so I can at least appoint an attorney for her so we can give her attorney discovery relevant to her, because I'm sure they want to go over all of that with her. Mr. Fallharbor. I would urge the court, if the court is going to appoint her a conflict panel attorney, please give them as much time as necessary because we've already got several attorneys out of this. The court. Out of the loop. So can you have somebody from the conflict panel here tomorrow that's not Mr. Fallharbor and not Mr. Hano? I'm going to have you just call the conflict panel and see if you can get me the clerk. What time? Can you have Miss Johnson here like 9:30 tomorrow, Ms. Token? I will try. I can talk to my investigator on her, and I'll know over the lunch break. The court. Okay, let me know at 1:30. We'll let them know. Wait and see if they can send somebody from out of the area, Mr. Fallharbor, and not Mr. Doche or Mr. Benner. Mr. Token, I'm sorry, Your Honor. I don't know why the public defender's office would be available. Maybe I'm missing something. The court. I saw a public defender's name in here somewhere. Was there a Christopher Riley originally charged? Mr. Myers, yes. The public defender had a Christopher Riley. I think I feel safer just doing the conflict panel attorney. Mr. Token, that's fine, Your Honor. I just wanted to check the court. Yeah, and it can't be Mr. Token, Farquhar, Hano, the court, Mr. Benner or Mr. Doche, Hano or Farquhar, Mr. Gass. We have a new guy, Mr. Christensen. The court. Of course, how old is this case? It wasn't originally filed by him in the DA's office, was it? Mr. Myers, it was filed in September 2011. Mr. Token, it was not filed by him. The court. And no appearance by him, I would assume, and he didn't review it and did not file it. So maybe Mr. Christensen would be a safe choice. So I'll try and get him here and see how much time he'll need to go over that with her. Anything else we can take up now? Mr. Fallharbor. If it has not already been done, I think You're honored. We'd also need to have information with regard to prior crimes of moral turpitude of the witnesses. The court. Any witnesses? Yeah. Mr. Fallharbor. Most notably the victim. The court. Okay. So, Mr. Fallharbor, that realized, and God knows who else. And the Rileys, and God knows who else. The court. Mr. Token, make sure that you review the witnesses you intend to call. Mr. Token. Yes, Your Honor. The court. Either rap sheets, crime, or moral turpitude. If you want, I know you can't do it, but if you have any rap sheets there, I order you to turn over copies. Mr. Token. I have two, Your Honor. The court. I'll order you provide copies to the defense. Mr. Token, I'll do that right now. The court. Then that way there's no issue. Then we can argue about what's on there. Anything else we can do this morning? No. So far as scheduling with Ricky Johnson, I'm going to need to wait to see what the attorney says to see how much time he needs with her on the gang stuff with, is it Detective Whitten? Mr. Token, yes. The court. When can we do that? Well, when is the court? All I'm going to do today is bring in a jury and hardship them. Tell me when he's available, and I'll just lay out some time, and I'll just tell the jury when to come back. We'll work around these hearings. Mr. Token. Okay, the court. Because I have a feeling it would take me more than one panel to get enough people to start picking a jury. Mr. Fallharbor. Does the court think that realistically we can be done with the true selection on Wednesday the 18th, or are we going to shoot for the 17th? Realistically, I think the 18th, and we're probably given as many preemptories as there are, and given how small the courtroom is, even if I start with 60 people, I have a feeling we're going to need supplemental panels. Given that we only hold 60 and there are a total of 70 preemptories, I have a feeling we'll probably at some point need a supplemental panel, but I could be surprised. You can pleasantly surprise me, Mr. Token. Then we need to get The court, I'm not necessarily counting on that, Mr. Myers. The gang issue, if that's going to come in much at all, I think then we have a longer jury selection process, Mr. Token, and we'll need to know that before we actually start board during the jury. The court, maybe we can do that tomorrow, Mr. Token. I'll leave Mr. Whitten a message. The court, let me know at 1:30 when he's available tomorrow. We'll do that. And then Ricky Johnson, we don't necessarily have to have that issue resolved before we start picking a jury, or do we, Mr. Fowler? I think there's two issues. She puts that creative problem with jury selection. One is this fear issue with her, and that's gang-based, and where that goes. And then these conversations that she's having with others that might have hearsay confrontation and random problems. But I think if the prosecution and her lawyer work out a plea agreement, that's going to cause her to testify. At least then we can get to those issues. But I'm not sure if that's going to get done tomorrow. The court, we'll play it by ear. But I'll hardship a panel today, and we'll see how far we get. We'll talk this afternoon when we're done. And if you can get a hold of your investigator, detective, and whatnot, then we have to get the reports of Miss Johnson's last statement of being kidnapped and Mr. Token Wright, the court. And we can, Mr. Token Wright, are the recording. I'll ask the investigator if he has a recording. The court, all right, see you back at 1:30.